This is Michael Popok with a Legal AF hot take. Does Donald Trump have a strategy, a trick up his sleeve to try to avoid jail time coming off of next week's Manhattan DA criminal prosecution trial, the election interference Stormy Daniels cover-up case? Is his strategy, ultimately, whether he likes it or not, is he going to try to convince Judge Merchan to give the jury an instruction so that they can convict on the lesser included crime misdemeanor of falsifying a business record under New York law, rather than convict him of the felony of using the business record fraud in furtherance of another crime? I'm going to unpack all of that. It is an interesting strategy that's been proposed by a former prosecutor who writes for Politico, Ankush Khardori, and I'm going to explore it here with my experience as a New York lawyer. First, let's talk about the charges and what the case is about, to remind everybody. Then I'll break down the charges, the lesser included offense, misdemeanor, that's buried within the felony prosecution, and then what could be Donald Trump's strategy right here on this hot take. Donald Trump has been indicted, 34 counts of business record fraud, which has been ratcheted up to a felony because in New York, if you combine business record fraud, which is under its penal law 175.05, falsifying business records. But if you couple that, that's a misdemeanor. And if you couple that, however, with the reason the person falsified the business records was to cover up or conceal or to promote another crime, in the case of Donald Trump, it could be election fraud, the cover-up of the Stormy Daniels payment to prevent the voters from knowing that he had done some sexually misconduct things with her outside of his marriage, or some sort of tax evasion fraud. Then when you put those two things together, you then go to another part of the penal law in New York, 175.10, and you get a first degree, you get a felony. You get a felony, which is a Class E felony. So it's a two-step process in New York for this type of crime. So yes, there are 34 felony counts against Donald Trump, but they are a two-step process under New York law. It's the marriage of a misdemeanor, business record fraud, with the concealment or promotion of another crime, which then creates the felony. But could Donald Trump ask the judge to consider under other New York law that he give the lesser included offense charge to the jury, allowing them an exit ramp to convict him of the misdemeanor, but not the felony, which means he'd get low or zero jail time, likely zero jail time as a result of that conviction. In order for Donald Trump to convince the judge of that, the judge, in reviewing the evidence, has to believe that there is a reasonable view of the evidence which can support a finding by a jury that the lesser included offense could have been committed without the greater offense, the second crime, having been committed. In other words, that the jury could have concluded that it was a standalone business record fraud case, not in furtherance of the crime, election concealment, election interference, or a tax evasion. Why election interference and tax evasion? Let me light on that right now. Their argument, the prosecutor's argument to the jury, will be that Donald Trump, this is the conspiracy, right? This is the many steps of the conspiracy, that Donald Trump freaked out along with his campaign after the Access Hollywood hot mic video was leaked from a couple of years earlier, right around the time of October of the campaign against Hillary Clinton, October 2016. And in it, he was heard his own voice. He's never denied it's his voice or that it's a phony AI-generated audio clip. He said he could regularly sexually assault women and get away with it because he's a celebrity. Okay, that leaks. Freaks out the campaign. Campaign needs to tamp down all other women who are now coming forward to claim that they also participated either willingly or unwillingly in sex or had a sex attack by Donald Trump. So they needed to implement a catch and kill program devised by Donald Trump, Michael Cohen, Alan Weisselberg, who's now in jail again, Rikers Island, formerly chief financial officer for Donald Trump, and David Pecker, who is the editor of the National Enquirer and a friend of Donald Trump's. The goal was to buy these stories and then bury them. Buy and bury, catch and kill. I've heard it referred to as well. And then on the books and records of the company, as entered by Alan Weisselberg, and so the indictment goes, as approved by Donald Trump, it was not recorded as a hush money payoff to Stormy Daniels for $130,000 to stop her story from going public. It was recorded as payments for legal services to Michael Cohen, then the inside fixer for Donald Trump, who he entered into the NDA, the non-disclosure agreement with Stormy Daniels. He paid Stormy Daniels. He took out a loan, then got repaid by Donald Trump in a series of payments, some of which started before Donald Trump won the election, and then when they were successful in the election interference after he was in the White House. And then a series of payments to Michael Cohen, including a bonus for having participated and helped develop this scheme. Of course, the circumstantial evidence here that's going to be presented to the jury is that they can conclude that no person would create this elaborate of a scheme of cover-up if he wasn't committing a crime or wasn't doing it with willful intent to commit a crime. Who does this? You would just pay Stormy Daniels. If there was nothing wrong with what he was doing, Donald Trump, he would have just paid Stormy Daniels directly and then recorded it on his books and records as a non-disclosure agreement payment to Stormy Daniels. Okay, you don't have Michael Cohen lay out his own money, then get reimbursed, listed as legal fees on the business records of the company, and pay off Stormy Daniels, right? Especially when there's an audio recording of Donald Trump talking to Michael Cohen, in which you can tell they're talking in code, but they're talking about paying her in cash directly, and Michael Cohen saying, "No, we don't want to pay in cash. We got to pay. We got to pay with some sort of checks to get a receipt." Now, when that was recorded on the books and records of the company, it was recorded as a legal expense. The second crime is now coming into place. If it was an illegal campaign contribution to Donald Trump, in other words, it benefited the campaign because he was trying to get elected. This is the reason he was doing it. He just wasn't doing it out of the goodness of his heart to go give Stormy Daniels $130,000 and get a non-disclosure agreement through Michael Cohen in return. Right? That's ludicrous. He was doing it to help his political and electoral fortunes. He was helping the campaign. That is an illegal campaign contribution that was not recorded. That's the second crime. That could be the second crime, which makes sense because Michael Cohen pled guilty to a crime just like that related to Stormy Daniels in this very transaction, this illicit transaction. The second crime, because it hasn't yet been fully developed by the Manhattan DA prior to trial, could also be that they got a benefit in their tax returns by listing this as a business deduction, legal expense to Michael Cohen. I mean, a payment for hush money to a person you had sex with is not generally seen by the IRS or other taxing authorities as a legitimate business expense. But a payment to your lawyer, legitimate business expense, if it's true. That could be a business deduction. So now you have the second crime. The statute, 171 that I'm dealing with here in New York, 175.10 doesn't define what the crime has to be. It just has to be a second crime. Now, let's get back to the lesser included offense. If the Judge Merchan, the same judge that Donald Trump has been bashing mercilessly, trying to get him disqualified, going after his daughter, so they have to rely on Judge Merchan here. If Judge Merchan, the trial judge, decides that based on the evidence, the jury could also reasonably conclude that it was just a standalone business record fraud case, business record fraud intent, not an intent to conceal a second crime, he can let a lesser included offense charge go to the jury to allow them to convict on a misdemeanor, not a felony. And if Donald Trump gets the misdemeanor conviction instead, right, because now he's given the jury a choice. They don't have to let him go. They can punish him, but at the lesser misdemeanor level, which means he's not going to jail. And there would be a political calculus by Donald Trump that he can survive, his reputation, his brand, his electoral fortunes can survive a conviction on a misdemeanor. And he probably has already concluded that because his people don't care if he gets convicted of a misdemeanor. He can just say, business record fraud, I did it. Business, that's all I did. Record fraud. It happens every day in New York. Misdemeanor, 2024 election interference, he'll do that. And they probably will have calculated by that point that that is a path to the White House for him, to plead or get convicted of that, even though there is polling that suggests that any conviction at any level is going to drain votes from him in what should be a very close election, or what will be a very close election. So is this the strategy? Now, in order to implement the strategy is I'll take a conviction for misdemeanor, not felony, he's got to get Judge Merchan to agree. And there's no appeal process for this. This is at the discretion of the trial judge. There'll be an appeal at the end, but not now. And so they've got to make this decision relatively soon as they're presenting evidence and make argument to the trial judge, who will report on it here on the MeidasTouch Network and on Legal AF what happens. But this is a very, I think, a very strong analysis that Mr. Kadari has come up with that I like a lot. And I haven't done some of the other background research here and with my own experience, but they got to get Judge Merchan on board. If he doesn't on board, then that jury instruction doesn't go to the jury, and they are just faced with 34 felony counts. And then it's going to be up to Donald Trump to try to argue that there is no second crime, right? There's no election fraud crime. Hard to do when Michael Cohen went to jail federally for a very similar crime for this exact same set of events, or that there was no tax evasion or tax purpose to this. That's a harder path, a narrower path for Donald Trump to succeed in front of a jury in Manhattan. I'll just tell you that straight. And to get a 12 and to get 1 out of even 12, because it's a 12-0 vote, you have to get a unanimous jury in New York, 12-0 in this case for the prosecution. But, the Manhattan jurors are not in love with Donald Trump. I mean, there may be a few that are. But I think this is an interesting posit here. Does he try and shoot for the misdemeanor conviction? But again, he has to get the trial judge interested in doing that. And then for those that think, well, what is all the evidence that's going on here against Donald Trump? And isn't it circumstantial? Sure. But circumstantial evidence is often a very strong version of evidence, that there's no other inference that can be drawn from a series of steps taken by Donald Trump to conceal an activity. In other words, why would you conceal the activity? As I said earlier in the hot take, you would just pay Stormy Daniels directly and record it in your books and records as payment to somebody I had sex with. But he didn't do that. He conspired with Michael Cohen to make payments along with David Pecker to her as if they were coming from Michael Cohen with a non-disclosure agreement signed by him, Michael Cohen, and then Michael Cohen was repaid over time as a legal expense and as a bonus. You don't do all that if you're not covering up. Sometimes it's the crime and the cover-up, and that's the circumstantial evidence here in the structure that will be presented to this jury. We'll continue to follow what happens with all things. Just because the trial starts with the picking of the jury next week doesn't mean the other motion practice, including jury instructions, aren't going to be before the judge with the lawyers. The jury is either they're allowed to go to lunch early, or they're told to come in late, or they're let go early from a trial day. There's going to be 4 trial days a week. They're going to go dark one day to let the judge catch up at his other cases, and thumbs up on that. and then they'll have the lawyers will have, I'll tell you, in a criminal trial, there's lots of activity that goes on the jury has no idea about on purpose, as the judge and the lawyers continue to struggle over certain issues that get down to what the jury can hear in terms of evidence and how the jury will be ultimately instructed and what the jury verdict form is going to look like. And we'll be able to report on all of that. It's not going to be televised. There's not an audio of this. We're going to have to rely on court watchers who are inside the room that we trust and rely upon, and then our own analysis here on Legal AF and on the MeidasTouch Network. So if you like this kind of legal analysis at the intersection of law and politics, join me every Wednesday and Saturday for a podcast on called Legal AF. Join, you'll find out why it's called that. And then on hot takes just like this one. Until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.